This webinar is grounded in the relationship between the environment, especially as it relates to our multilateral environmental agreements and traditional cultural practices and trade. In addition to it being grounded or having a context within the EPAs that the CARIFORUM region have signed on to between the EU and the UK, some of our own treaties, such as the revised Treaty of Chaguaramas, which establishes the Caribbean community, including the CARICOM single market and economy in Article 58, which addresses natural resource management, and the revised Treaty of Basseterre, establishing the Organization of the Eastern Caribbean States in Article 24, also makes provisions to the environmental sustainability within the region. With regard to the Convention on Biological Diversity, which several of our speakers will touch on today, the Cartagena Protocol, most of the CARIFORUM states are parties to that, as well as to the Nagoya Protocol, where we've got 7 CARIFORUM states that are party to this protocol. And so that forms a context for which this webinar is being hosted today, and it has this objective, as we've heard, to the exchange of good practices. So we'll start with our first round of speakers in the first topic, which will cover measures to protect genetic resources, traditional knowledge, and folklore, looking at access and benefit sharing in the EU. Our speakers will be Dr. Mery Ciacci, who is the Director General of Environment in the EU Commission. Mery is an International Policy Officer at DG Environment Unit, the Global Environmental Cooperation and Multilateralism, is in charge of monitoring the implementation of the Nagoya Protocol in the EU, mainly through the EU Access and Benefit Sharing Regulation. She also follows the international negotiations and all discussions related to access and benefit sharing under the Convention of Biological Diversity and the Nagoya Protocol. She holds a PhD in international and European law from the European University Institute. We welcome our first speaker, Dr. Ciacci. Can you please take the floor? Welcome.
Thank you. Thank you very much for your introduction. Thanks a lot also for inviting me to this very interesting webinar, and I mean, congratulations for the project. It is actually an honor to have the possibility to explain how we try to implement the Nagoya Protocol in the EU, and I think it will be a good opportunity also to clarify a little bit what are the critical aspects and the challenges that we are all facing with the implementation of ABS policies. I would now go, straight away with my presentation. I will briefly introduce a little bit the content of the Nagoya Protocol and the type of access and benefit sharing policy framework that it introduced. I don't know how many of you are familiar with the Convention on Biological Diversities and all the other complementary protocols. I heard the previous speaker mentioning the Cartagena Protocol, but this one actually focuses on biosafety, and today we will only look at the access and benefit sharing aspect, so that mainly this is embedded in the Nagoya Protocol, the third objective of the CBD. Then we will look at how we implement this in the EU at the EU level, and precisely through the EU regulation number 511 adopted in 2014, the one that we usually call simply EU ABS regulation, and then a little bit the challenges for implementing the Nagoya Protocol and also the EU regulation. So in 1992 and 1993, there were negotiations that led to the adoptions of the Convention on Biological Diversity, which mainly focuses on the conservation of biological diversity and its components, as well as on their sustainable use. And finally, the third objective of this convention is also to ensure that benefit that are derived from the use of biodiversity and its component are fairly and equitably shared with a country from where such genetic diversity is derived. Including also by appropriate access regulation to genetic resources, but not necessarily, actually. It's one of the possibilities. And this is the origin of the acronym ABS, where A stands precisely for access to genetic resources, and benefit sharing refers to the obligations to share fairly and equitably the benefits deriving from utilization of such biodiversity. The third objective of the CBD was initially implemented through some guidelines. Then the parties to the convention did not consider such guidelines binding enough, or at least they were not satisfied with the outcomes delivered by the guidance. So there was a request to adopt a legally binding instruments focusing on the third objective, so on access and benefit sharing. After 10 years of negotiations, the Nagoya Protocol was adopted in 2010, and it's precisely focusing on measures. Actually, the Nagoya Protocol is trying to set up a common framework for those countries who wish to regulate access to their genetic resources and benefit sharing obligations upon all parties to the protocol. So basically, these are the pillars, what we call the ABC of ABS. So these are the main three pillars of the Nagoya Protocol. The first one is access. And as I said, this is not a mandatory obligation under the Nagoya Protocol, but in case parties to the protocol wish to regulate access to their genetic resources, they should do it following more or less the same standards, which mainly consist of issuing a prior informed consent and also negotiating mutually agreed terms for the benefit sharing. The Nagoya Protocol does not only apply to genetic resources, but also to traditional knowledge associated to the genetic resources. And in case parties decide to have some regulations on prior informed consent, they should also consult or take into account, when it is opportune, the rights also of indigenous peoples and local communities, in particular when it comes to traditional knowledge associated to genetic resources. This pillar is not implemented at the EU level, because actually at the EU, you know, the EU is an international organizations, regional integration, and we work on the basis of attribution of competences, and everything that deals with the sovereign rights of parties over their genetic resources is competence of the member states. So at the EU level, we could not adopt the legislations to regulate access to genetic resources. This falls under the competence of the member states, actually. Sorry. Then the second pillar is precisely the part that concerns obligations to share benefits. Can you hear me well? I hope so. Yeah? All
yes,
right.
we do.
Because I hear some interferences, but now must be my computer. So the benefit sharing pillars is actually subject to contractual obligations. So under the Nagoya Protocol, the state can regulate access to their genetic resources, and then in this context, they can require that those users of genetic resources and traditional knowledge associated to genetic resources that obtain a permit to have access to such resources and traditional knowledge, they should engage into some private bilateral contractual negotiations with the country providing access to such resources or knowledge, and then basically sign a contract with the conditions and for the benefits and the sharing of benefits. So this is subject to private terms in the end, to private contracts and private laws. So this is not also regulated at the EU level and nor at the level of the state. This is a bilateral relationship between the country providing access to the resources of the traditional knowledge and the user, which can be a company in the biotech sector, or could be also researchers doing his PhD or university. It depends on the context. And then it is, again, a private contract. Then we have the compliance pillar under the Nagoya Protocol. And this is actually the part that is mandatory on all parties to the Nagoya Protocol. And it requires all the parties to check upon their users whether they have respected the access and benefit sharing regulations of the country from where the resources of the traditional knowledge that are being utilized in their territory have been originated. This is the part actually that we implement at the EU level through the EU ABS regulation, and we mainly do this through the due diligence obligations that apply to all users in the EU territory. I hope that was clear. So yeah, as I said, in the EU, we don't have legislations for access. This is left to member states' choice because it's in their competence. Currently, we have 5 member states who have adopted access legislations. These are Spain, France, Croatia, Malta, and Bulgaria. And Denmark and Finland, they have special provisions concerning indigenous peoples and local communities for what concerns traditional knowledge associated to genetic resources. So everything that relates to the protection through specific instruments of regulation of traditional knowledge and genetic resources, this is at the level of the member states, and currently these are those member states who have decided to have some specific regulation for this. All the others, they have considered that it was not opportune, or at least some of them they're still considering. Then, as I said, the benefit sharing is between the user and the provider country, and then the compliance is what we have harmonized at the level of the EU with the EU ABS regulation. The EU ABS regulation is complemented also by an implementing regulation adopted by the Commission in 2015 to set up practical measures and necessary steps to complete the implementation of the regulation, and also by another instrument, which is a guidance document, mainly to try to support both the member states and the users to interpret the content of the regulations, because actually it's quite a complex piece of legislation, as it is trying to ensure compliance with not with EU legislations, but with legislations adopted and enacted by third countries, by other countries. So to what our regulation applies, here is a little bit of a summary of the geographic, temporal, and material scope of the regulation. Mainly all genetic resources and traditional knowledge associated to genetic resources that are coming from parties that are parties to the protocol, from countries that are parties to the protocol. They fall in the scope of the regulation when the DNA or the traditional knowledge is utilized by some user in the EU, unless such resources already fall under the scope of another instrument. I don't know if you have ever heard about the FAO Treaty on Plant Genetic Resources for Food and Agriculture. This is an instrument that is considered a specialized international instrument on ABS. Those resources falling under the treaty, for instance, they do not fall under the scope of our EU ABS regulations, because we consider the compliance follows different rules, and then it's for something else to assess this. For the EU ABS regulation, if a user utilizes genetic resources from the treaty, it's considered compliance under the terms of the FAO treaty. It doesn't need to prove compliance under the EU ABS regulation. And of course, it applies to those genetic resources and traditional knowledge associated to those genetic resources when there is a relevant and applicable access legislations in place. So it means that the country providing access to such resources needs to have ABS legislations already enacted and in place. And how can you find out about this? In principle, the Nagoya Protocol established the obligation for all parties to upload information about their measures and about also the institutions to contact in the ABS clearinghouse, which is basically a hub, a platform where you could find all sorts of information. We do have a little bit of a problem with this because actually parties are a little bit slow in uploading information concerning their ABS measures, and also about the national focal points. So this is a bit of an issue with the protocol that we have. Then, of course, the genetic resources or the traditional knowledge have to be accessed after the entry into force of the Nagoya Protocol, so there is no retroactive effect of the regulation, and they need to be utilized in the EU. Basically, the obligations is upon users to exercise due diligence regarding legality of access and sharing of benefits. And the obligation is to seek, keep, and transfer to all subsequent users in case there are the international recognized certificate of compliance where available, which is mainly the prior informed consent, so the PIC, when it's uploaded into the ABS clearinghouse, it becomes an IRCC, an international recognized certificate of compliance. And if this certificate is not available, then the users should try to gather all relevant documents and information concerning the origin, the date of place of access, the source, any rights and obligations, including whether there are IP rights related, some PICs, some MAT. They should collect all these, keep them, and transfer when necessary. In case there is no sufficient information, the user should discontinue utilizations not to be found in breach of due diligence obligations. So the part on checks on users is again implemented at the level of the member states. So member states have designated some competent authorities. They are trying to identify the potential users for genetic resources and actual users, and then they try to they have the duty actually to carry out some checks on the basis of a plan that is a plan developed on the risk-based approach criteria. On the basis of this, regularly they undertake some checks to see whether the users in the EU of genetic resources and or traditional knowledge have respected all the necessary requirements from the country of origin. In case not, there is, of course, there are penalties. This again, since this is again something that falls in the competence of the member states, they're not the same in all member states. Member states have adopted different type of sanctions. For the great majority, these are administrative sanctions, but in some cases also criminal sanctions. Then we have established two actually checkpoints at the level of the EU, and the checkpoints is also measures that is established in the section on compliance in the Nagoya Protocol. The first checkpoint is at the level of the research funding. So when researchers in the EU receive funds from both public source or private source, and this research falls in scope of the regulations because it deals with some genetic resources coming from a country party to the Nagoya Protocol, because it's using some traditional knowledge still regulated by the country that is party to the protocol. Then they have to submit a due diligence declarations to show that they have been compliant with the requirements of the country that provided access. The second checkpoint is instead at the stage of pre-commercialization or final stage of development of the product, and we have identified these moments. For instance, when the market approval is sought, or when a notification is required to put the new product on the market, when the product is simply placed on the market, when the result of utilization is sold or transferred for the purpose of one of the previous moment, or when the utilization ended in the EU and its outcome is sold and transferred outside the EU. In these cases, the company, this is mainly companies, they have to submit a due diligence declaration to prove that they have collected all those pieces of information and documents that I mentioned before to be compliant with the legislations of the country that granted access to those genetic resources. Maybe what is interesting here for you to know is that there is no IP offices identified as checkpoints. This was something that was for a long time debated also under the Nagoya Protocol and then also in the context of the EU. And it was not considered like they would be like the adequate checkpoint. There was no agreement in the end in the context of the Nagoya Protocol for this. What is interesting for you to know is probably that many member states, they have established some relationship between their IP offices and the checkpoints through the disclosure of origin. So those countries that have adopted or they have included the requirement of disclosure of origin in their patent legislations, for instance, or in this case, some member states foresee that information about the applications, patent applications, where disclosure of origin is available, is transferred one or two times per year, depends on, the regulation that the member states have agreed upon, is then transferred to the checkpoints, who is in charge to identify users and potentially can decide that, okay, these companies that have filed an application for patent and we see that they are using genetic resources coming from a country that is a party to the Nagoya Protocol, potentially is a user under the term of the regulation. So they may decide to have check on them and their compliance. So, okay, here is, I'm not going to explain this in detail, but it's a flow chart that you can then look at if you want to see how the chain works from the moment where, either researchers I've prepared to or a company has concluded this research, has concluded its R&D activities, and then the due diligence declaration is transferred to a platform that we have created for all EU member states. It's called Declare. And then from Declare, relevant information are transferred to the ABS clearinghouse. And when this information is transferred to the ABS clearinghouse, the information in the due diligence declarations, such a document becomes a checkpoint communique. And this is very important because it's the proof for the user in the EU that he was compliant or she was compliant with the legislations of the country that provided access. And this is actually the real added value of, if you want, of the Nagoya Protocol in terms of legal certainties, and because this document allows then the country of origin to have the proof that those users have respected their legislations on ABS, and for the user is a safeguard so that he cannot be accused to be to have misappropriated genetic resources or traditional knowledge. Well, Declare is the platform that I told you is used to file the due diligence declaration. We also have two instruments to encourage compliance in the EU. One is a register of collections and one is best practices. Currently we have one best practices adopted in the EU, recognized, and 3 collections. I'm not gonna spend too much time on this because this is really more for of interest for the users than maybe for for you in this case. So what are the challenges that we're facing with implementing ABS? Well, the concept of ABS certainly is quite difficult per se. It's not a traditional piece of environmental legislations. Is indeed dealing also with the aspects of fairness and equity. So it's not a straightforward concept. It requires quite a lot of investment from the side of the countries who need to implement it, and also from the side of the users who need to comply with such legislations. Another challenges we're facing is the fact that most countries that have adopted access and benefit sharing legislations, they have adopted different legislations. So even if the Nagoya Protocol was there to set up some form of common framework, in the end, we see that there is a proliferation of very different and complex ABS measures, because maybe the scope of application is not always the same. There are different interpretations also on the Nagoya Protocol and whether it should have or not retroactive effect. So we see that there's a bit of challenges there, and certainly there is a need to harmonize and create more simple measures for access and benefit sharing, because in the end, this is then turning a little bit against the promotion of joint research, for instance, or R&D activities. Then the UABS regulation is also quite a complex piece of legislation. The challenge we have is also the fact that we don't have information all the time about the ABS measures, because parties do not always upload the information in the ABS clearinghouse. Well, I've mentioned the fact that sometimes the scope of the ABS measure is not clear, and this creates some issues for the researchers and for the users. What is this? And then, I told you, I also mentioned a little bit the difficulties of the relationship with IP offices. Nowadays, in the context of the CBD, there's also discussions ongoing on whether the ABS should also include digital sequence information, which is information related to the DNA of the genetic resources, but this is another quite complex issue. I'm happy to discuss this at another moment, but just to give you the full picture. And I think I can conclude here.